Welcome to the Brigham Young University Family History Library webinar series. My name is Braden Knudsen. I'll be your host for this webinar today. We'd like to thank you for joining us. We'd like to invite you to participate in the polls that we have down at the bottom of the screen as we get going. Especially let us know if you have any topics that you'd be interested in hearing about, learning a little bit more about as we keep going on in our webinar series. Our next webinar after today will be by Catherine Grant, titled Getting Better Search Results with Wildcards. And that webinar will be on Tuesday, October 10th at 5:30 p.m. Mountain Daylight Time. So we hope to see you again on next Tuesday. Today, we'll be pleased to hear from James Tanner, who will be giving a presentation titled Common Law Marriage and Genealogy. James Tanner has a bachelor's degree in Spanish and a master's degree in linguistics from the University of Utah. He received a Juris Doctor degree in law from Arizona State University. He worked for 39 years as an Arizona trial attorney. He previously owned a retail computer business and an Apple Macintosh software company. James has over 35 years experience in genealogical research and is an avid blogger for Genealogy Star and the blog Rejoice and Be Exceeding Glad. He served for 10 years as a missionary at the Mesa, Arizona Family Search Library and is currently serving at the BYU Family History Library. He is the co-author or author of over 25 books on genealogical research and has presented at expos and conferences around the U.S. and Canada. James has 7 children and 33 grandchildren. And as we turn the time over to James, just to remind everyone that there is a question box on the right-hand side. Any questions that you put in there, we'll make sure to get answered by the end of the presentation.
Howdy, this is James Tanner. Glad to be here for another BYU Family History Library webinar. And remind everyone that these webinars are recorded and uploaded to our BYU Family History Library YouTube channel on youtube.com. And encourage everyone to subscribe so that we can at least have a little bit of notice there above all of the background noise of all of the stuff that they put on YouTube. Today we're going to talk about common law marriage and genealogy and perhaps explain this concept and show what we can and cannot do about that kind of a situation if it existed with one of our ancestors or relatives for that matter. Here's some of the genealogical research challenges that we have. We have enough, but here's a few more just in case you hadn't thought of all the other challenges that you think you have. Okay, so one of the most common ones is finding the maiden name of English-speaking female ancestors. Now, I had to qualify this by the word English because we understand that, for instance, I speak Spanish fluently, and I do a lot of research in Spanish genealogy. And an interesting thing is, of course, the women, when they get married in a Spanish-speaking country, do not change their names. They add their husband's name to their name, but they maintain their maiden name. So you always know the maiden name of the woman in a Spanish-speaking country. And it's the same in many other countries of the world. The English-speaking countries are really not unique, but kind of on the outside of the people who maintain the wife's maiden name after marriage. But it turns out to be a fairly substantial challenge for English language genealogical researchers because of a lot of other reasons, and that has to do with the status of women particularly in Western European and even more particularly in English, historic English society, and also as it was transmitted to the United States through the colonies. And another great challenge out there is discovering the life stories of female ancestors. Because of the situation that women were placed in as far as owning property and being able to maintain a separate existence as such, there's relatively fewer accounts of the women in history and the women in our ancestry, in our lines, than there are of the male representations in our lines. That's a standard fact. It's got, obviously, in today's world, that would all come out as prejudice and all sorts of other evil things, but you really can't impose your current feelings and your current political and social and religious and whatever other views you might have on history, because history is history, and it's what it was, and that's how things were, and we have to deal with it as researchers and genealogists. And so part of the whole challenge is bringing the history of women out of the dark, out of the area that we have. Now, fortunately, we have an abundance of records, at least for the last 200 years, and then a little fewer back 300 years, and then after about that time period in the early 1700s, 1600s, about that time in the 1500s, everybody starts to disappear. It's not just a matter of the women disappearing, but all of the individuals disappear from the history. So the history is not only prejudice against women, but it's been prejudice against everybody, because a lot of the records have disappeared over the years or never been kept. And so we have to deal with that record situation. But as far as finding maiden names in the first couple of hundred years of our ancestry, it can be a real challenge. And I think that's one of the greater challenges of doing research. Okay, so we can solve that problem. And most of the time people say, well, I'm just looking for a marriage license or a marriage record. Well, that's the problem that we're facing. That it is true that we can almost more commonly than not find the name of the maiden name of the spouse, of the wife, in a marriage record. But as marriage license and marriage certificates and all of the things that we think of that are associated with getting married in our day and age are really quite a very, very recent historical invention. In many places in the United States, these kinds of records were not kept by states or anything other than the churches, or sometimes on a local basis, well into the 20th century. So it's in some places like Arizona, for example, most of the records for births and marriages and deaths were not mandatory until in the early 1900s, around 1906, and they weren't universally kept until around 1920. So you're not really going to find marriage licenses and marriage records, certificates as such, very far back. And part of what the challenges that you face in doing research is to determine the historical depth of any of the records that you're searching for. So in other words, if you're looking for a marriage license, it might be a good idea to look on the FamilySearch.org research wiki for any jurisdiction in the United States and find out when the first marriage records began to be kept in that jurisdiction, just so you're not looking for something that is obviously not there because it was never kept. Once you do that, then we're going to have to get into alternate records for marriages, and that becomes another thing. And these records, by the way, are only helpful if the wife's maiden name is included. So many of the records that we see in online family trees have the husband's name, but have the wife's given name only, Mary, Sarah, whatever. And that's basically because the records that we found so far do not show her maiden name, her family name. But there's lots of places that we can go to get that information. And we're going to talk a little bit about that, but that's kind of the subject of another presentation. But because we're going to focus today on a relationship that kind of works outside of this formal marriage license type, church type marriage. So what happens if there aren't any marriage records? So what do we do about it? I've already kind of alluded to that, and the fact that there are alternate marriage records. But we have to also understand that even if there is no official record or any record that we can find of the marriage itself, that there still may have been a legal marriage. We don't have to assume that there was something wrong with what these people were doing They may have been legally married, even though we can't find any kind of evidence that there was a marriage that was recognized by some kind of civil authority or even ecclesiastical authority. So I think there's a very, very common misunderstanding all over the country. It's not just, one local area or anything about what's called common law marriage. But we kind of hear about this as we do research or as we do, especially if we get into any kind of social, historical things. And very, very commonly, if we get into some of our ancestral research. So we come up with the problem of this common law marriage. And the term common law marriage is subject to a lot of misuse and misconception. And I have to get the whole point of this presentation is to kind of clarify what is and what is not a common law marriage, and what kinds of records we could expect to find or not expect to find if that in fact exists. Okay, so what's the common law? First of all, it's not a marriage, it's a marriage and they call it by the common law. So we have the idea here is to understand exactly what the common law is. The common law is the part of English law that's derived from custom and judicial precedent rather than statutes. And it's often contrasted to statutory law. Okay, so what does that really mean in English? What that means is translated into in this common speech is that this is court-made law. This is law made by judges when they make rulings in individual law cases. And it is also by custom. Custom in England and the way that the custom was viewed by the courts has created a body of law that we call the common law. And the contrasting to statutory law, which is made by legislative bodies, passing laws. When you say something is a law, you generally mean that some legislature at the national, state, or local level, some kind of body, has enacted a regulation or law that is something that you're bound to observe under certain circumstances. Okay, so for example, give a really simple example. A statute or regulation or a rule would be the speed limit. So when you're driving down the road, you see a sign that says speed limit 35 miles an hour. Well, you can say, fine, I don't care about that. And you can drive 50 or 60 or 70 miles an hour. But what would happen if you do that? Well, if you're unlucky enough, you might get caught by a local officer of the law and given a ticket. Well, that's a statutory law. That's what we call statutory law. So how do we enforce judicial laws? Well, we enforce judicial laws by going to court. So unless there's a court action, there's really no way of knowing what the law will do or how it will be applied to any particular situation that's in the common law. What's a common law situation? Okay, so you walk onto my property and I'm upset because you're on my property, and I say you're trespassing on my property and you caused damage to my property, and so you owe me some money for the damage. Well, the common law recognizes that may be what we call a cause of action, a right to go to court and enforce your right to get some money out of a person who caused you damage. But there's no statute that says that. There's no law you can pull up off a book that a legislature has passed that allows you to get X amount of money simply because somebody walked on your property. You'd have to go to court. And if you prevailed, if you won in the court case, you might get some money out of it. And that is the common law. That's what we do. And of course, we can argue back and forth on those. And that's what lawyers do who go to court, is to argue back and forth in the United States about the common law. Now, we're one of the only people, one of the very few countries in the world that actually has common law, by the way. It's a peculiarly kind of English thing. There's a few other countries that recognize judicial precedents or the rulings made by judges, but not anything like we do in the United States or in England. So we really have inherited all of our system of courts and judges from our English ancestry. Now there's a little bit of side view here, and what happens is that we have parts of the country that were heavily influenced by Spain, and so there's some parts of our marriage laws and our laws concerning property ownership that are influenced in some states by what we call civil law, or the statutory law that originated in Spain. Okay, now if that isn't complicated enough to start off this thing, then we'll have to get into something that's a little more difficult to understand. Okay, now that was easy. This is going to be a little bit harder. The term here that we've got to understand here is called coverture. And it's a legal doctrine. Now, what is a legal doctrine? Legal doctrine means it's recognized by the courts. In other words, your relationship, the relationship between two people is established by the laws that have been passed, as well as laws that are traditional or enforced by judges according to the common law. And it was common in the United States, in America. I'm going to use that term more inclusively instead of just in the United States. It was common back and before in colonial times, and until the middle 1800s. That this idea of coverture, and the word is used a little more differently today, but it's still used. It's just not used in the same fashion. But what it meant originally was that when a woman married her husband or became married, all of her rights and obligations were subsumed by those of her husband. What does that mean? It means the husband got the rights, the woman lost it all, period. That may now seem outrageously unfair to someone living in the world today, but this is the way it was. And the wife's legal status was called a femme covert, which meant that she was married and had no other rights outside of the marriage other than those that she had given to her husband, and which she had done voluntarily or involuntarily or whatever, simply by getting married, that she lost all those rights. And essentially, the husband and the wife were one person in the law, and the person was the husband, not the wife. Okay, so that's the way it worked. Now, if you think about that, when you're doing genealogical research, the problem that you have with this is that it seems so foreign to what we have today that it is almost impossible to envision how people operated under that system historically. But up until, like I said, the mid-1800s, this was the way it worked. And it wasn't a question of women's rights to vote. It wasn't a question of women's rights to do anything. It was a question that they were not separately considered to be separate human beings from their husbands. And so there wasn't any kind of question about, oh, can you vote? Of course you can't vote. You're not a separate person. We're not counting you in our count of people who can vote. And so that was the situation that we were faced with early on. Now that may help to explain some of the things you read and some of the situations and problems that you have. And perhaps you can begin to understand why the wife's maiden name, may not have been recorded so often. It's because that was not important. It did not matter. It wasn't something that they had any particular reason to divulge or to be associated with. So what happens, however, is that even beginning in very early times, as far as you want to go back in history, the lack of a legal marriage complicates property ownership. And it complicates who is the property owner. Okay, so now let's think of the situation here. Let's suppose that under whatever law that existed in whatever state or county or colony or in England at the time, and it was under the time of coverture early on, if a man married the woman, then there were automatic property consequences. In other words, the wife became one with the husband owned all the property and owned everything, and all of the wife's, what they call sole and separate property, was subsumed under the ownership of the husband. So the husband automatically owned everything that the wife had. That might explain some of the books you read about historical fiction and things like that, all the people who kind of understood this and write about it and that kind of thing. By the way, most of the historical representations that you see in the movies and on TVs and on on online and stuff like that, highly politicized by today's attitudes because they really didn't have as much interest in anything that happened as it tries to show. They're always writing novels about the conflict between the wife and the wife wants to do something that's independent of the husband, and the husband is always denying her the right to do it. Well, it didn't happen that way. Most of the time, they had no concept of acting separately, and so that it wasn't something that they wanted to do or wish they could do. They just simply didn't do it. And most of what we hear about that in the romantic novels of putting the women back in that time are people who wrote those when they were beginning to become aware of the problems that were occurring because of that particular law and the way that it worked. Okay, so now we have some other questions here. We have a couple of things called Dower and Courtesy. First of all, Dower and Courtesy rights arise on the death of a spouse. Okay, so this is the situation where, okay, the husband and the wife are one, but what happens if the husband dies? And that's the question that's answered by Dower and Courtesy. And dower is the wife's interest in her husband's property upon his death. It was usually about a third of the total amount of the property that the husband had, and she was legally entitled to that 1/3 interest during her lifetime to support herself and their children. Then the rest, when she died, all of her, whatever she had in that 1/3, went to the children. Now, this was not totally universally enforced across all of the colonies, say beginning in the 16 and 1700s. Even early in the 1700s, if a woman survived her husband, she had control and ownership over her property, and beginning in some colonies and at some times in the early 1700s, women began assuming the right to dispose of their property through a will. So you're going to find wills written by women beginning about mid 1700s and then into the 1800s when it became more common. But so this is what they got. The courtesy was the right of the husband into the wife's property when she died. Okay, so it was the other way around. So absent a valid marriage, okay, let's suppose there was no valid marriage out there, that they had just lived together without ever getting married formally under the law, so that the law recognized the relationship between them. These rights didn't exist. So the question comes up, who owned the property? And that is the kind of question that's addressed by the idea of a common law marriage. So the courtesy rights, going back to courtesy rights, is the husband has an entitlement in his wife's, in everything the wife possessed at her death. So in a sense, she couldn't even leave it to her children, any of her rights to her children if she died. Her children got nothing. Her husband obtained all of her interest in everything that she might have owned in that marriage until he died. And that's when the children might get what was left of the property, or would get their portion of the property. But if the marriage was not valid, or it was absent, it was an absent marriage, there was nothing that showed that they were ever married, then these rights did not exist. And so once again the question arises as to who owned the property. And that kind of situation, it was very difficult for even the courts to determine who were the legal rights to who had legal rights to the property. Now, what happens today? Today we're a long way down the road from when all this happened, and we have very detailed statutes, meaning the legislatures have stepped in, regardless of the way that the courts have decided cases and how they think that the law should go. The legislatures around the country have made their own laws, and these are called our probate laws. And so our probate laws today determine who gets what and how much they get and where they get and how and soon they get it and what interest the husband and wife may have in the separate property. Okay. So what makes a common law marriage? How do we what do we do there? Well, when a man and a woman live together under certain circumstances, and usually in the legal term produced issue, which in legal terms means had children, um, then they themselves, and they held themselves out as being husband and wife, and they intended, everybody knew they were married, but they never were. By the way, this is not unusual. If you begin to think it's unusual, you don't really know that much about your ancestors. You really ought to get in there and do a little bit of history, because you're going to find out that's new. I have some ancestors, I call them ancestors, I'm going to call them my close relatives, who I knew all of my life growing up as my aunt and uncle, and who I found out many years later as an attorney, not because I knew anything else, but because I was an attorney, that they were never married. And then they did get married, and then they immediately got divorced. Both of these people are dead now, so it's not something I'm talking about, it's something that's alive, but it was this was a long time ago. So that's what happened. But when a man and woman held themselves out as husband and wife, and depending on the time period in the place where they were living, it was always part of the local common law of the area they living. It could be 1 year, it could be 7 years. There's this undercurrent of tradition about common law marriages that said that they had to live together for 7 years. Well, that is like, it's sort of an urban legend. It doesn't really exist. It was not 7 years. It was never any place established as 7 years. It was more different time periods. Usually 1 to 3 years was the time period. But they had to do what was called per verba de presente, which meant they had to be presently holding out or saying that they were married. They have to tell people that they were married, in other words. And that was followed by cohabitation. You couldn't just tell people you were married and never lived together, then they had to live together. But once the marriage is formed, the common law marriage was formed, the couple was treated legally the same way that a traditional married couples were treated. Okay, so that was what answered the question about what happens if they never got married. Because they were, under the law, they were considered to be married if they lived together and expressed a willingness or desire or whatever, held themselves out to be husband and wife. Now, what happened next? Well, obviously there's no record of the marriage, so no matter how long you look and no matter how much research you do, you may never find that these people were ever actually married at any particular point in time, which does not mean they weren't legally married. It just means that they didn't have any kind of formal date on which they took vows or went before a judge or went before some other officer or a minister or something and got married. Okay. By the way, this also happened, and one of the complications that happened is that at sometimes the predominant religious community in America and in England would only recognize marriages performed by the predominant religion. So in other words, we go back in time in England, at many times in the early history of the Church of England, marriages in any of the other Protestant religions, any Protestant religion that was in existence back in England, were not legally recognized by English law. So those people were not considered to be married, even though they had a church marriage and a priest or minister had performed a marriage ceremony. So for them they were married, but for England they were not. And so what you will see sometimes is that people got married because of something that arose in their in their life. Okay, so For example, I have a family of ancestors who emigrated from England to Australia under a government subsidy program out of England. This back in the 1800s. But one of the requirements to obtain the subsidy was that they had to be married in the Church of England. And so these people all went and got married in the Church of England, even though they had been married previously in their own churches. Okay, so this is kind of the thing that that happens. Now, so a marriage doesn't have to be recognized in the jurisdiction where the marriage is consummated. So a marriage by common law or a marriage by an unauthorized authority to perform a marriage does not necessarily have to be recognized by the court. Now, there's other things they call this, and these are actually not all the same thing. They're very similar to common law marriages, but they're generally, in some cases, euphemisms, words used instead of saying common law marriage, but they're also slightly different in the way that the law marries it. This is a sui juris marriage, means a marriage that's created by the law itself or under the law. This is a marriage, regardless of the circumstances in which the marriage was contracted. Okay, an informal marriage, sometimes referred to as an informal marriage, meaning they never took the formality of of complying with whatever real regulations were required at the time to recognize a marriage in the community. A marriage by habit and repute. This was another way of doing this. Now, when did all these things come up? They generally came up in the context of the death of a spouse, or they came up in the context of a separation and what you would call a divorce, but we're going to get to that in a moment. But the idea here is that the wife wanted to have her dower interest, for example, in the husband's property, but everyone said, but the law said, well, show us that you were ever married. And the answer is we were married because we lived together for all this time. Well, the only way they're going to be able to prove that and actually obtain the interest in the property would be to go to court and have the court rule that they were married by sui juris, or marriage by habit and repute, or it was an informal marriage, and therefore the court was going to recognize that they were in fact legally married, even though we have no record of the marriage taking place. Okay, or a marriage in fact is the same kind of thing. And this is the term I used a moment ago, a marriage per verbum de presente, which means words of present assent, meaning if you asked them if they were married, they would say, yes, we are married. And that was how it came about. Now, an interesting thing that is kind of hard, this is probably where the law starts to become a little bit, out there in the twilight zone, is because cohabitation does not automatically create a common law marriage. It's not just the fact that the people live together that they are quote unquote married. They are only married if they go through the process of what I just said. They had to make it a formal assent. They had to represent themselves as husband and wife. They had to consider themselves married, that kind of thing, or it doesn't work. As long as they recognize that they are not married and they live together, that doesn't help them or the law in determining the rights on a separation or a death. Okay, so these things are also known as domestic partnerships. They're also known as registered partnerships. They're known as conjugal unions. They're known as civil unions, and they've got a whole bunch of other designations depending on the jurisdictions. Now, the rights of parties in these types of relationships are determined by the laws of the place where they live at the time that the events occurred. Okay, so if a couple were cohabiting in Kansas, they'd be liable under Kansas law. They'd have to tell whether they were married or whether they had a domestic partnership or anything else as far as the law. Now, if you start to understand this, you'll begin to understand some of the conflicts and some of the problems that were inherent in the concept of creating alternative marriage contracts or relationships. So this is sort of the way it can be. And here's the basic. There can only be a common law marriage in a jurisdiction that recognizes the common law. Okay, so you can't create a common law marriage in a state that doesn't recognize a common law marriage. Where do you go for that? Arizona. Uh, I lived in Arizona most of my life, and Arizona is not a common law state as far as marriage is concerned. It's a civil law state. It's called a community property state, and it does not recognize a common law marriage. Is a common law marriage, let's say they got married in, common law marriage was recognized in Florida, in someplace like Mississippi or someplace that recognized a common law marriage. Could they move to Arizona and still have their marriage recognized? Well, that's another problem, and so we'll talk about that. So why is it called a common law marriage? It's called a common law marriage because it's recognized in some jurisdictions that you can get married without a license or a ceremony simply by living together and saying that you are married. So unfortunately, this is not a universal. Unfortunately, depends on how you look at it. But anyway, it is not a universal thing. You're not universally married just simply because you live together, and it is only in certain jurisdictions in the United States that actually recognize it. Therefore, some of the most valuable records for determining a woman's maiden name are missing. And this is important to understand this because we spend an inordinate amount of time. A lot of people just spend their lives looking for a record of a marriage or their record of a death or their record of a birth or whatever. And that kind of problem, it just may not exist. In other words, they just didn't have to have it. They didn't do it, and they suffered the consequences under the law because of it. Okay, so these are the current states. This is as of today in the United States. This is not historic because it may not have changed in the past, but here's a list of the states that presently recognize common law marriages. You'll notice, for example, that Utah is on the list, where I happen to be giving this presentation here in Provo, Utah. Arizona is not on the list, where I lived most of my life. And you can see other places that are that maybe perhaps are a little bit surprising to you. For example, New Hampshire recognized a common law marriage for inheritance only. Ohio, if it was created before 1991, before October 10th, 1991, and Pennsylvania only before 1905. So you really kind of have to get into this history a little bit if you want to understand how this comes. And Oklahoma is the real exception. It possibly only recognizes if it was created before 1998, but they're in conflict of whether or not after 1998 the common law marriages will be recognized. So you can really get into some situations that way. So how do you know if there was a common law marriage? So if there's no documents and there's nothing to show that they got married, how can you do it? Essentially, you have to rely on other records that show that they lived together as husband and wife. And what are those records? Well, and in this case, we have to understand this, that a common law marriage really never exists until it's contested, until there's somebody goes to court and contests the fact that the husband and wife were never legally married. Then it really didn't matter, because even the fact that they never had a formal wedding ceremony or marriage that was recognized by either somebody in the court in the state or county or wherever, doesn't really matter until somebody disagrees with it. If everybody assumed that they were married and everybody believed it and everything, and they allowed it to go forth, then it was. But in order to enforce a common law marriage, if there is a disagreement in a contest, the contesting party has to disprove the marriage, or the parties who want to enforce the marriage have to prove the legal requirements for a common law marriage have been met. Um, and unfortunately, if they move out of the recognizing jurisdiction before meeting all the legal requirements, then they're not married. There's no legal marriage out there. Okay, this is, let me give you some examples. Okay, so let's say someone entered into a common law marriage in Georgia, and there was nothing that enforced it, no recognition at all, and they died in Arizona. What happens to the couple? Well, they fall under the jurisdiction of the Arizona law as to the rights of the parties upon the death of one of the spouses. And so they're going to have to try to prove that they were married. Arizona does not recognize common law marriage, and so it's going to be a little bit of an uphill battle. Now, would Arizona have some other legal theory that might give one or the other of the spouses their interest in the property? Well, it gets more and more complicated the longer you talk about it. So every single instance of this problem is going to have its own peculiar resolution, distinct resolution, because that's the way the common law works. You go to court, and the court, and if necessary, a jury, decides the issue. So let's say there was a common law marriage in Georgia with a decree that actually made it a common law, recognized the law, the marriage in Georgia. And then they died in Arizona. Well, yeah, okay, and in that case, Arizona has to recognize the Georgia decree. Why? Because we have something called comity that says, not comedy, comity with a T, comity, which says each of the states have to recognize the law of the other states. And then it becomes becomes a constitutional issue. And so that's hardly ever contested. So if they're married in Georgia and had some kind of a decree of their marriage, then that's going to be recognized in Arizona. Well, what if they live together in Arizona? You could live together in Arizona your entire life and you would never be married. There is no recognition of common law marriage in Arizona. Time does not create an automatic or understandable interest. Now, does it create other interests in property? Yes, it may, but it does not create a marriage. Okay, so common law marriages are now more complicated because of the recognition of domestic partnerships and civil unions. You just have to understand that this is not a simple part of our law. This is really one of the complex core issues of our law today. And what's happening in here is that we get in the middle of this. By the way, we walk into the middle of this every time we start doing research in genealogy back into our ancestors' relationships. Every time we ask the question, what was this wife's maiden name, we're opening up the door to getting into a situation where we may or may not have a legal binding marriage. The couple may have had a lot of children, but never been married. So we just have to recognize that this is the case, and we can do some historical research. And if we understand the law and the custom in the area where we're doing the research, it may assist us in understanding those problems. Okay, so this is what the parties will have to do to prove that they had a common law marriage. They have to say they were legal age and capable of giving consent, that they were capable of entering into a marriage, so there was nothing that would preclude a marriage, like parties were too closely related or some other thing, underage or problem like that they actually lived together, and that they treat each other as they were married and present themselves to the public so that other people believe that they were married. So all of these things, these are what you call the elements of proof to proving that someone had a common law marriage. So if they never challenged it, or they wouldn't go to court, who would ever know that they weren't married? The answer is no one. There's no way you would have known that these people weren't married, except for the fact that as genealogists, we never were able to find a record that shows that they were. Okay, so don't become fixated on a particular date or event. Don't think that you have to find a marriage record in order to prove that these people were married. If they lived together, if the census records show that they were married and living together and had children, and all the other records that you find say that they were husband and wife and grew old together or whatever, or spent considerable time together, that's probably enough to determine that they were married and not be. Now, that I'm not telling people not to go out and look for the records of a marriage. That isn't the whole point here. The point is that when you spend a great deal of time and it appears obvious that there is no record of the marriage, that you might start thinking about whether or not a common law marriage could have been recognized in that jurisdiction. So this is one of the rules, and it comes very close to one of my basic rules of genealogy, which I'm going to talk about probably in my next presentation, one of my next presentations, and that is the absence of a marriage record does not negate the fact that there was a marriage. Just because the jar is empty does not mean there was nothing in it. How's that for a really weird philosophical problem when you get into genealogy? Okay. Now, this is the real crux. There is no such thing as a common law divorce. If you're not common law married, you can walk away from it and there's no divorce. Now, that's good, and that's really, really bad, because in a divorce situation, the wife had no rights, has very limited rights, but she did have some rights. If there's common law marriage, then there's no such thing as a common law divorce. So they had to go and prove the marriage, but they had an uphill battle in proving that they had any rights in a divorce. So the lack of a legal marriage affects property rights and interests during the coverture, during the time of the marriage, child custody, inheritance rights, contracts, and conveyances. So everything is affected by the lack of a legal marriage. This gets to be a real interesting problem in a lot of situations. So if there is no marriage, formal marriage, there's always an uncertainty about the existence of the marriage, and it would depend on the circumstances so what should a genealogical researcher do? Use a variety of records to document the families. Don't try to rely on the big three: vital records, census records, and death records, grave records. You've got to be a little bit more expansive and start getting into records that, like land and property and probate and court records and anything else that could possibly be out there that would be part of making up the record of people's lives. You can look at birth records to see if they show the names of the parents. Fortunately, we do find the names of both parents and their surnames on some birth records, so that's helpful. Look at land and property records. Look at wills and probate records. These are probably the best ones for establishing that the person was married and the name, at least the given name of the wife, and sometimes the surname, but it's kind of a bonus if you can come up with the wife's family out of a probate. Look at the death records and burial records. Sometimes in burials, the wife's family would insist that her maiden name be included on the tombstone or something, and so it's not impossible that you can find records of the wife and her maiden name in these circumstances. You can go ahead and there are standard genealogical estimates that can be made, standardized time periods. You can estimate a marriage 1 year before the birth of the first child if the record is not present, but you should always put that down on your record, the way you transcribe that, as an estimate. So it should be EST, or estimated date of the marriage. And the important thing here is to keep looking. It's something that you really have to keep searching. Now, and what I said, this is kind of contradicts the idea of becoming fixated, but really what you're doing is looking for more records about the family in general, and if there are extra records or anything out there that might show a marriage, then they'll show up if you just keep persisting in looking for records in general about that particular family. Okay, well, thanks for watching. This has been another BYU Family History Library webinar. reminding everyone once again that these webinars are recorded and uploaded to our BYU Family History Library YouTube channel, and we'd ask you to subscribe if you would, please. Turn it back over to you.
All right. Well, thank you very much, James, for the wonderful webinar. Definitely a lot of good information, and hope that everybody was able to learn and take this information to enhance your research. So our next webinar will, like I said, will be on Tuesday, October 10th. And so we hope to see you back for that one as well. Have a great weekend.